Hi, I'm Jonathan Hafetz, and welcome to Law on Film, a podcast that explores the rich connections between law and film. Law is critical to many films. Film, in turn, tells us a lot about the law. In each episode, we'll examine a film that's noteworthy from a legal perspective. What legal issues does the film explore? What does it get right about the law? And what does it get wrong? How is law important to understanding the film? And what does film teach us about the law and about the larger social and cultural context in which it operates? Our film today is Bridge of Spies, a 2015 Cold War legal and political thriller directed by Steven Spielberg. The film is based on the true story of American attorney James Donovan, who was assigned to represent Soviet spy Rudolf Abel after Abel was arrested at a hotel in New York and prosecuted for espionage. The story takes a turn when American pilot Francis Gary Powers is captured by the Russians after his plane is shot down over the Soviet Union while conducting a surveillance mission. Donovan is then tasked with negotiating a high-stakes prisoner exchange, Abel for Powers, that ultimately succeeds in a climactic scene on the Glienicke Bridge that connected East Germany with Western-controlled West Berlin in 1962. The film is not only highly entertaining, it also provides a window into important legal issues around national security, criminal, and immigration law that still resonate today. Joining me to explore these issues are Lenni Benson, Distinguished Chair in Immigration and Human Rights Law at New York Law School, who is one of the nation's foremost authorities and experts on immigration law, and Jeffrey Kahn, University Distinguished Professor at SMU Dedman School of Law, a leading scholar on constitutional and counterterrorism law, an expert on Russian law, and the author of a must-read article on the Abel case published in the Journal of National Security Law and Policy. Welcome, Lenni and Jeff. Great to have you on the podcast.
Thank you, Jonathan.
Thank you, Jonathan. Good to be here.
So let's just step back and give a little context. Who were the people? What was the sort of background of the story of the spy Abel?
Rudolf Abel is the name we use for a man whose name we actually didn't know throughout the entirety of these events. We later learned from a tombstone in Moscow that his given name at birth was Willie Fisher. He was actually born in the north of England to parents who were Bolsheviks, emigres from the East, and his father actually was an agitator who worked alongside Vladimir Lenin. So after the Russian Revolution, the family moved back to Moscow, and over the course of time, that led to Rudolf Abel, also known as Willie Fisher, also known as Emil Goldfuss, also known as Mark, also known as many things, to really have the perfect credentials for a spy in the Cold War. He had an honest-to-goodness, legitimate British passport. He spoke the King's English. He was very fervently a supporter of the Soviet cause. And when he left the Soviet Union to become ultimately the spy master for North America, he also had a credential that probably was not so pleasant. And that is, he had a wife and a daughter sitting in Moscow whom he knew if he ever wanted to see again, he had to work very, very carefully. James Donovan, on the other hand, couldn't have been more different than Rudolf Abel. James Donovan was an outstanding New York attorney. He wasn't focused on criminal law. He was focused on civil litigation and insurance law, among other things. He was a rising star on the scene, on the New York legal scene, and he had a very distinguished career in government service. He had worked in the General Counsel's Office of the OSS, which was the predecessor to the Central Intelligence Agency. He had worked as a Nuremberg prosecutor alongside Colonel Robert Story and others. I mentioned Colonel Story because the building in which I sit is named after him. He was a former dean of SMU Law School. And he probably had, and lost because of this case, the opportunity for an outstanding political career. He could have been a New York senator, and I think that it's quite possible that this was the case that he accepted because he believed it was the right thing to do, but ultimately it cost him that future career.
That's interesting. In the film, there are a number of warnings that come from his partner at the film, played by Alan Alda, and his wife, Amy Ryan, that, he shouldn't take this case. There's a lot of pressure against him. He certainly received criticism and people were giving him sort of dirty looks on the subway and things like that, but he didn't get the sense that he might have gone onto those political heights. It's quite interesting.
He was not the first person asked. A lot of other attorneys in New York actually turned it down, saying they didn't want to be tarred by having Rudolf Abel as a client. But this was a man, I think, of genuine courage. And although you always have to be suspect of autobiographies and memoirs, if there's one book you ought to read, you really want to know more about the details of this case from his perspective, he actually kept a lawyer's diary, which he called Strangers on a Bridge. And it's a pretty good, detailed summary of his day-to-day workings. You can cross-check a lot of the facts. And frankly, I think somebody on Spielberg's team, or maybe the Coen brothers who helped with the screenplay, must have read this book, because there are some excerpts from the dialogue in the movie that are almost word for word from the book.
I wanted to say something else about the time and the milieu, though, that, we're looking at a period in American history where not just this case, but throughout society, there was growing fear of communism. The U.S. is in the post-World War II moments of trying to stop the expansion of communism. And of course, we sometimes just call it the McCarthy era. But it had many dimensions to it on both state government levels and federal levels. And so when we think about a lawyer being brave like Mr. Donovan, at this time, it's very common to be asked to take a loyalty oath. When I was a very young college student and I worked for the government of the state of Arizona, where I'm from, I still had to sign that loyalty oath. At the time I went to law school, 1980 to 1983, it was still a crime in Arizona, officially on the books, to teach anything written by Karl Marx or that espoused the communist revolution. So there are these echoes throughout. We're going to talk about modern implications today. But I think when we look at what Spielberg might have been trying to do in the film, he's trying to also introduce us a little bit to an awareness of how the emotion of politics, the fear of the atomic bomb, the scenes with Donovan's son learning to duck and cover, is trying to give us an understanding of the climate and tension, not so much to justify what the government did, but I think for the audience to be placed into the time and place. And I'll talk more about how that was particularly a dangerous moment for people living in the country who had not acquired U.S. citizenship.
Just to double down on Lenni's excellent point, 10 days before the first day of the trial, that's when Sputnik was launched. And so the trial begins in mid-October 1957. On October 4th, 1957, Sputnik is launched into orbit. And every 90 minutes, you could hear the beep, beep, beep of this Soviet satellite circling the planet. That was a very real, tangible manifestation of the anxiety that Lenni speaks of, even though the McCarthy era is winding down at this point, and it's been almost 10 years since the first Soviet atomic explosion, there is a palpable fear of communism in the United States. And for a lawyer like Donovan to accept this case was an enormous risk, and I think took substantial courage.
I found on YouTube a government training film for people working in security areas, where Donovan is quoted about the case, and they use the hollow nickel case to explain how vigilant you must be when you're working for the Department of Defense or in a corporation that is part of the weapons manufacturer. And that's made long after this case.
Just picking up on your points, you kind of see this tension in two ways. There's this idea that, right, of course, that Abel should have a defense. The idea that American justice is on trial.
Okay, here's the thing. The Soviet spy they caught, we want you to defend him. Here's the indictment.
Not sure I want to pick that up.
The accused doesn't know any lawyers. The federal court tossed it into our lap. The bar committee took a vote. You're the unanimous choice.
It was important to us, it's important to our country, Jim, that this man is seen as getting a fair shake. American justice will be on trial.
Well, of course, when you put it that way, it's an honor to be asked.
At the same time, there's pressure on Donovan to kind of not litigate the case too zealously, right? So they want to kind of showcase that Abel's going to get a fair trial. He's going to have a defense, of course, but Donovan shouldn't be pushing too hard, and he's doing so at, some professional and personal sacrifice to himself and his family.
Tim, you did a great job. You fulfilled your mandate and then some. But the man is a spy. The verdict is correct, and there's no reason to appeal.
There's ample procedural reason. We know the search is tainted, and Fourth Amendment issues will always weigh more heavily in an appellate forum. We've got a good shot.
What goddamn hell are you talking about? We were supposed to show he had a capable defense, which we did. Why are you citing the goddamn Constitution?
Tom, if you look me in the eye and tell me we don't have grounds for an appeal, I'll drop it right now.
I'm not saying that. You know what I'm saying.
Tom is saying there's a cost to these things. A cost to both your family and your firm.
One of the things that actually surprises me a little bit, and I'm sure it had more to do with the State Department and CIA's desire to have a showcase trial exposing Soviet espionage. One of the things that surprises me is that they just didn't use immigration law completely and ignore criminal law. Because when you are in an immigration proceeding, it's civil law. You're not entitled to appointed government defense. You can provide your own at your own expense, or pro bono, we say for free. And that the government, in many other situations, when they have a foreign national, they will simply use the great power the federal government has inside of civil immigration proceedings to narrow and control access to the foreign national through the use of detention, access to no discovery, no exchange of documents. Secret evidence is possible in some kinds of removal hearings where even the respondent can't know what is being presented against them. So the fact that they made this a espionage criminal trial, to me, indicated there were politics behind that as well, because they didn't need to do it if they just wanted to detain or to deport Colonel Abel.
You know, I'm not sure I would call this a showcase trial. It's certainly true, I think, that what the government really wanted was to be able to turn Abel into a double agent. And so the use of the immigration law was very desirable because it kept Abel out of the public eye. If they had gone and obtained an arrest warrant and arrested him, they would have had to present him to a U.S. commissioner, which is the equivalent of a U.S. magistrate today, and there'd be a public arraignment. And that would just blow the cover off any attempt to use Abel as a double agent. What they really wanted was to turn him and use the Soviets' web of spies, which frankly would, I think, be quite an embarrassment to the United States in the way that we read now that a part of the motivating factors for having the ex parte hearing on the 7th floor of the Justice Department and completely out of the public eye was in part to hide the embarrassment of not being able to patrol Long Island very well during World War II. It was a bit of an embarrassment that Abel could operate for so long, so well in the United States. And so when they couldn't turn him after real serious effort, and we'll get to the eerie resonance with the post 9/11 cases in a short while, when they couldn't turn him, then I think the interest turned towards some sort of deterrence. And so this was a capital case, and it was a capital case, which meant it had to go through a federal trial.
Just for our audience, capital case means death penalty.
Yeah. He was accused of atomic espionage. And at the time, I'm not quite sure I can think of a worse charge for someone in that day and age. So you can look at whether this is a fair trial or not in a couple of ways. And one is that not only did he get court-appointed counsel, but the counsel was appointed at Abel's request, and this shows his intelligence and knowledge of the system. Abel requested that the judge consult with the local bar association to pick a lawyer, not to have the judge pick a lawyer or to tell the government to go find a lawyer. It was the bar association that chose James Donovan. So that's the first point. Second point is this was a 10-day trial. The prosecution called 27 witnesses. There were over 100 exhibits admitted into evidence. And so that shows, I think, a serious adversarial process. It also had a jury. Now, on the one hand, you could say that this shows that an adversarial jury trial can also work just fine, even in a top espionage case, even involving national security. On the other hand, the jury deliberated for only 3.5 hours, and some of the language in the judicial opinions generated by the case was probably better left unsaid and did evince a sort of strong thumb on the scales for national security considerations. On the other hand, some of the things depicted in the movie like ex parte conversations between James Donovan and Judge Byers, the district court trial judge in the case, at his home. I can't find any evidence that that ever happened. And the insinuation that Donovan used personal connections to convince the judge not to apply the death penalty, but to sentence Abel to over 30 years, that did not happen. In fact, Donovan's advocacy for keeping Abel in prison as an insurance policy, he needed to be traded in some future case. That was a conversation he had with Assistant Attorney General William Hopkins of the Internal Security Division of the Justice Department on the eve of trial, and then again in the sentencing phase after the trial. So a mixed record, you could say, about whether it was a fair trial.
Did the government, if Donovan was trying to, he was making his pitch for Abel not to be executed and instead be given a long sentence and held potentially for a trade if an American was captured, as would happen with Francis Garrett Powers. Did the government support that? The government attorneys support that? Were they still pushing for capital sentence?
My recollection is that the government recognized its utility. I don't recall there being very sort of single-minded, we must have a capital sentence in this case. On the other hand, I think there was certainly an awareness that there was certain public pressure. The Rosenbergs had been executed for espionage. Now, Donovan again and again and again pointed out that a significant difference between Rudolf Abel and the Rosenbergs was that Donovan perceived the Rosenbergs to be traitors to their country, whereas Abel was serving his country. So it was a difference between the work of a spy, honorable or dishonorable, reasonable minds can differ, versus the work of traitors. And that was a significant difference. But I say it was a mixed record as well because, Donovan had long experience in U.S. government circles. And for instance, when it came to, and this doesn't appear in the movie, when it came to the cross-examination of a government witness that would have led to the exposure of a lot of government intelligence information, Donovan was anxious and could be accused, I think, of pulling his punches a little bit. We didn't have the Classified Information Protection Act back then. And so as you read in Donovan's diary, there was a sort of quote-unquote gentleman's agreement between the prosecution and the defense about just how deep to go in cross-examination of one of these government witnesses, Master Sergeant Rhodes, who had betrayed his country when he was working in Moscow. So again, a mixed record.
Well, let's go back for a minute to the arrest, which sets up the movie and sets up some of the legal issues. He talked about the trial, and there's a question of factual guilt. Was Abel a spy or not? But the central issues in the case, certainly in the film, are around actually the legal motions, the effort to suppress the evidence that was, Donovan argued, illegally seized. And that's the case that goes to the Supreme Court. So what happens when Abel is arrested, and how does this set up some of the legal issues that are explored in the film?
Spielberg sets us up beautifully, I think, in the film to feel a sense of urgency. We are following these FBI agents that are apparently engaged in a day of surveillance. We're not told everything from the FBI agent's point of view. And they lose him in the subway. And he looks like a cool Mark Rylance's performance in this film is extraordinary. But Mike Rylance playing Colonel Abel, he just is so calm in this hot, sweaty, dirty Brooklyn subway, and they lose track of him. So then the cars are rushing, the agents are running. And if you've watched enough television shows in the United States, you think, oh, it's an exception to the warrant requirement because you're in pursuit or something. The first-year law student is going, got to get into the apartment before the evidence is destroyed. But all of that is drama, I think. And so now we'll turn to our expert, Jeffrey, who will tell us what was really going on.
Well, I agree. Mark Rylance's performance is outstanding, and his quiet confidence and unflappability is really, I think, quite accurate. It's certainly what James Donovan remembers in his lawyer's diary. And it's a great film, and there's a lot that's historically accurate about this film, but not that opening scene. It couldn't be more incorrect, and it made all the difference in the world from the point of view of the actual legal motions to suppress the evidence. So Lenni, of course, is absolutely correct. The movie does suggest a certain urgency, and it also suggests that all of the players are FBI agents. And if you look at the closing credits to the movie, you'll see that indeed they're all listed as FBI agents, but they weren't all FBI agents that day. And so I just need to step back a little bit to say, first of all, there was no urgency. The United States government had been surveilling Abel for at least a month prior to this arrest. They would lose him at times, and this caused great anxiety in the FBI, but then they'd pick up his trail again. And so that month-long period of surveillance prior to the arrest leads to a disagreement that I have with the last surviving member of the prosecution team, an outstanding lawyer in New York named Anthony Palermo. And he and I disagree about whether the U.S. government could have obtained an arrest warrant on the information that they had. I think that they could have. He disagrees. Reasonable minds can differ. We can explore that disagreement later. But there weren't just FBI agents involved. In fact, there were a lot of INS agents involved. The Immigration and Naturalization Service, which at the time was a part of the Department of Justice. So Abel had been moving around, and he was living for a period of time in a hotel, the Hotel Lanham in Manhattan. And early in the morning of June 21st, Midsummer Day, 1957, 2 FBI agents knocked on his door, and when Abel went to open the latch, they pushed their way in. That's the language in the affidavit. There wasn't this breaking down of the door to find Abel with his teeth out in the bathroom. In fact, Abel was stark raving naked. It was so hot that night that he'd been lying in bed, sleeping in the nude, and had just gotten up to peek through the door. But the agents push in, and they sit him down on the bed. They call him by his rank, colonel, to let him know that the game is up. And Abel just goes into total silence mode. He won't answer their questions. He won't even look at them. He's just silent. He is the defendant that I think every criminal defense lawyer would love to have. He knew...
Every immigration lawyer. You do not have to speak.
Every lawyer. He knew his rights. And so he just sat there. And the agents tried. There were 2 agents in the main, Agents Gamber and Blasco. But most significantly and most obscured by the movie, what happened next was the FBI walked out, signaled to the INS agents waiting outside the door that they should go in, and they approached Abel and presented him with an administrative warrant for having violated the immigration laws. And then pursuant to that warrant, they searched him and the room for what they said was evidence of alienage. Now, the warrant was not signed by a magistrate judge. It wasn't signed by a federal judge. It wasn't signed by a U.S. commissioner. It was signed by an internal government official in the INS. And its advantage, as I mentioned before, was it allowed the government to keep Abel's detention completely secret. He is then marched out of the room. The FBI then comes in and starts searching the room after they go down to the hotel desk lobby to say, since the room is vacant, may we have your permission, hotel manager, to search the vacant room? And the hotel manager agrees. Of course, it's been vacated by the FBI. And so there's another element to what would become the motion to suppress all of the evidence. And I should say, Abel, for all his brilliance as a spy, was caught in flagrante delicto that morning. All of the evidence of espionage was all around him. Cipher notes, hollowed out wooden pads and pencils, all sorts of tools of the trade.
I just have to ask you, when they marched him out, did they put something on him, or was he a naked man going down the stairs of the hotel?
No. He was dressed at that time.
They let him get changed, right? They let him put on some clothes first.
Right. So he would have ordinarily, if he was an ordinary person subject to an administrative warrant on an immigration matter, be brought to the INS's offices on Columbus Circle in Manhattan. He may have gone there for a couple hours, but actually, and here's where things get eerily similar to post 9/11 cases, he's then brought to Newark Airport, where he's put on a government plane, flown 13 hours and almost 1,700 miles to McAllen, Texas, where he's held in secret detention for almost 7 weeks. He's not afforded a lawyer except for purposes of a deportation hearing where he's found deportable, but he's subjected without a lawyer to conveyor belt interrogation by FBI agents intent on turning him into a double agent and finding out all the information that he knows. If that doesn't sound familiar to those of us who've been following post 9/11 counterterrorism cases, you haven't been paying attention.
This sounds very familiar to me from a case that I recently was involved in. I'm a young man, about 16 years old, who had been released from immigration custody to his mother's care in Long Island. He was in the front yard watering the lawn when two plainclothes men came up to him and asked if he was his name. I'll use his mother's name because that's the name on the case, Saravia. And he says yes, and they took him into custody, held him for hours. His mother didn't know where he was. His mother called my office. We are trying to find out where he is. He is put on a plane for most of the day. They won't tell him where he's going. They take him to a children's psychiatric detention center where he's locked up as a security risk child, where he's put in a cell where he's monitored 24 hours, released out to go to the restroom or to eat, but always isolated from the other youth that are in the facility. It took me calls to Washington, D.C., to Health and Human Services, which is the agency that detains non-immigrant children. I made calls to the government counsel in the case because we were already representing him in an immigration case. He had never been in a criminal matter. He had been in a school altercation where someone accused him of stealing a bicycle, but that was all there was. But the school officials said, we think he might be in a gang because he wears blue and white. He has a Chicago Bulls cap, and the bull sign, if you do the finger sign of what the bull headgear looks like, it could be a gang sign. We eventually recruited. I was ready to go file a habeas corpus petition, but his custody having now been moved to Northern California, I recruited the northern chapter of the ACLU to file for him, and it became a settlement case about children that are rearrested for any reason by the immigration services and held through the agency of HHS must give a child what they call a bond hearing, even though there's no bond that's ever posted, but a custody release hearing. And so that just happened a few years ago. Litigation is ongoing. The government just reached a new settlement. You can be snatched off the street from your mother's house when you've never committed a crime and accused of being a security risk. So this is still alive in the law today, even if it's not something as powerful as the government alleging you're a 9/11 terrorist.
Abel never turned that summer. He just sat there. And when the government finally realized he's just not going to give them any information, and he's certainly not going to become a double agent, he's then returned to New York and brought into the public criminal justice system with arraignment on these capital death penalty charges of atomic espionage. And that was the basis of James Donovan's motion. He said, and he made this argument all the way through to the Supreme Court, where it was argued twice, that the government had a fork in the road moment in that Hotel Lanham when they pushed in through the door. Was DOJ going to act as a law enforcement agency, or was it going to act as a national security agency? If it was going to act as a law enforcement agency, then it needed to obtain a warrant to arrest and search, and it had to follow all the other requirements of a federal criminal prosecution. If the national security road was taken, then his clandestine seizure and his concealed attempts to turn him, if they didn't work out, well, the government couldn't then just turn around and choose the other law enforcement path, the road not taken. And on that ground, the evidence ought to be suppressed. So Donovan argued that the search of Abel's hotel room and the use of that evidence in the criminal trial was an unreasonable search in violation of the Fourth Amendment because it was not a good faith effort to search for evidence of alienage. It was just pretext to have the INS there in the first place in order to avoid a judicial warrant and subsequent publicity. And that was the argument that Donovan made again and again and again as he tried to suppress the evidence and then appeal the conviction after trial.
If I could interject some more history here. In the time of Attorney General Palmer in the Wilson administration, we had something called the Red Scare raids of 1919 and 1920. and 5,000 people or more across the country in coordinated raids by a young J. Edgar Hoover, a very nascent FBI, U.S. attorneys, and immigration officials, which were then part of the Department of Labor, rounded up people at English language schools, working in circle schools that those of you in New York may know that today we Ethical Culture Society. There were these societies proved for the betterment of people to educate them in mathematics or skills or trades or English or literacy. Horrific mass detentions of women, children, and men on Deer Island off the coast of the city of Boston. And in a real act of bravery, the acting Secretary of Labor, a man named Louis F. Post, ruled that most of the arrests lacked any kind of sufficient, reasonable inquiry into whether or not these were anarchists or a threat to national security, whether these people had in any way were subjected to the expulsion laws of 1917 or 1918. And he quashed almost all of the orders of removal, leading to impeachment hearings in the House of Representatives, which did not at all go to an article of impeachment being issued against him. Instead, it led to a severe criticism, which may have been in part politically motivated, against Attorney General Palmer, who at that point was one of the leading Democratic candidates for the next presidential race. And Palmer tried to justify some of what he had done as being necessary to the protection of the United States, in part because a bomb went off in front of his own home. I mean, there were bits of flesh of a human being and pamphlets in front of his own yard in 1919. So this massive argument of we have to round up the subversives, we have to stop this internal threat from the foreign, Louis Post was incredibly brave. And his book, The Deportation Delirium of the 1920s, is a fantastic read, and I highly recommend it. He's one of my all-time heroes. In the recent impeachment of Secretary Mayorkas, a lot of people said this is the first time the cabinet officer has ever been impeached. Louis Post came close, and that's because he was standing up for the rights of the foreign-born.
Yeah, one theme that really comes across here is the way the government would try to use, in the case of Abel, immigration law, where there are weaker protections to carry out things that it can't do in a formal criminal proceeding, something that the government would return to, especially in the post-9/11 era, with suspected terrorists through the label of enemy combatant or misusing the material witness warrant. And as Lenni, you pointed out, it still happens with immigration. I think the film does a nice job, actually, of kind of isolating this cherry picking, where the government tries to pick from the area of law that's helpful at a particular point. And Donovan makes this argument. You either have to classify Abel, you can treat him either as a criminal defendant, or you can treat him as a spy, national security spy, kind of a combatant in the war, if you will, but you can't do both.
Mr. Chief Justice, and may it please the court, the Cold War is not just a phrase, Yolanda. It's not just a figure of speech. Truly, a battle is being fought between two competing views of the world. I contend that Rudolf Ivanovich Abel, Colonel Abel, as he was called even by the men who arrested him, is our foe in that battle. He was treated as a combatant in that war until it no longer suited our government to so treat him. Accordingly, he was not given the protections we give our own citizens. He was subjected to treatment that, however appropriate for a suspected enemy, was not appropriate to a suspected criminal. I know this man. If the charge is true, he serves a foreign power, but he serves it faithfully. If he is a soldier in the opposing army, he is a good soldier. He has not fled the field of battle to save himself. He has refused to serve his captor. He has refused to betray his cause. He has refused to take the coward's way out. A coward must abandon his dignity before he abandons the field of battle. That Rudolf Abel will never do.
And this issue is what's presented, or one of the central issues presented to the Supreme Court, right? And what's a dispute in the court and becomes sort of the central part of the decision.
It's really an interesting record, both the legal arguments made in the briefs and the arguments made before Judge Byers, who issued a written opinion denying the motion to suppress this evidence, a unanimous opinion by the Second Circuit, and then a very narrow 5-4 opinion by the Supreme Court. So Byers was a very serious judge. He had been on the bench a long time, and he knew how to insulate his record. And so one of the things that comes across, at least to a lawyer reading his opinion denying the suppression motion, is that he again and again points out that the evidence that he has seen and judged is not showing any evidence of bad faith. And so there were really two parts to Donovan's argument. One was that the misuse of the INS as a tool for the Justice Department to try to go down both roads, that was evidence of bad faith. Judge Byers really insulates that in the record by saying all the evidence I've seen clearly show good faith on the part of these government officials, and you can trace that good faith assertion all the way through to the Supreme Court, where Justice Frankfurter, writing for the majority, says, well, questions of good faith or bad faith are just not open to us on this record based on what's happened below. So then the second part of Donovan's argument is that even if we can't show bad faith pretext, well, it was just categorically unreasonable to use an administrative tool in this way. And that gets to issues of pretext. So I teach constitutional law, and I can trace pretext arguments all the way back to McCulloch versus Maryland. And you can read this really beautiful language about how it would be the painful duty of the Supreme Court, if it was ever presented with a case of pretext, to strike it down as unconstitutional. But then you can find lots of examples in the record where a pretty good case of pretext is shown and it just doesn't happen. And so Justice Frankfurter writes a pretty formalistic opinion in which he points out that, well, when the INS was in the room, they were following their rules and they did everything according to the book. And then the evidence that was later found, well, that was found subject to a different type of search. And we've got to go case by case. So there's no real set formula here to say what's unreasonable. But then the dissenters, there was a very strong dissent written by Justice Douglas and a very strong dissent written by Justice Brennan. And both of them take very pragmatic approaches to say, well, let's just look at what's actually going on here and how easy it would be under these circumstances to circumvent the protections of the Fourth Amendment. And if you permit me, Jonathan, there's just a short part of one of these dissents that really brings this home. If I can just read it to you. This is from Justice Douglas. And he writes, the issue is not whether these FBI agents acted in bad faith. Of course they did not. The question is how far zeal may be permitted to carry officials bent on law enforcement. As Mr. Justice Brandeis once said, experience should teach us to be most on our guard to protect liberty when the government's purposes are beneficent. The facts seem to me clearly to establish that the FBI agents wore the mask of INS to do what otherwise they could not have done. They did what they could do only if they had gone to a judicial officer pursuant to the requirements of the Fourth Amendment, disclosed their evidence, and obtained the necessary warrant for the searches which they made. If the FBI agents had gone to a magistrate, any search warrant issued would be terms of the Fourth Amendment, have to particularly describe the place to be searched and the things to be seized. How much more convenient it is for the police to find a way around those specific requirements of the Fourth Amendment. What a hindrance it is to work laboriously through constitutional procedures. How much easier to go to another official in the same department. The administrative officer can give a warrant good for unlimited search. No more showing of probable cause to a magistrate. No more limitations on what may be searched and when. And each of those sentences is punctuated with an exclamation point. So they are very different points of view. And it was a hard case for the Supreme Court. Even Justice Frankfurter, probably based on his own past experiences, writes this formalistic opinion, but then feels compelled to say, well, of course there would be exceptions to this. He wants to keep the door open. Now, that door was slammed shut by Justice Scalia in a unanimous opinion in the Wren case years later, saying that we simply don't look at any subjective intent or concerns. We just look at the objective basis in law to determine whether a search or a seizure or an arrest was unreasonable. But it's interesting to see this struggle, even at this moment, and eerily familiar to those who have been following post 9/11 counterterrorism cases where judges have wrestled with this difficult dilemma.
The Wren case from 1996 involved a traffic stop. And the idea was there was a racial background to the traffic stop. The traffic stop was used as pretext for something else.
It's a fascinating case. It happened in Washington, D.C., and it involved some policemen who were in an unmarked car, the Vice Squad, if I recall correctly, and they just tailed a car that they were certain in their own minds, but didn't have any concrete evidence to support their hunch that this was a car that was involved in drug transactions. They stopped the car on a pretextual traffic stop, and then, sure enough, they find some drugs. Now, what's interesting about the Wren case is that it referenced, Justice Scalia referenced the Abel case. He referenced it in dicta, noting that the Abel court regarded Donovan's argument as a claim of, quote, serious misconduct, but didn't think the record could support any finding of bad faith by the government, since the INS had followed its procedures regardless of what the FBI had done. And in the Wren case, one of the arguments I recall the attorneys made was that it was just so out of sync with D.C. police procedures and the D.C. police procedural manual to use an unmarked Vice Squad car in this way that showed an intent to do something other than stop the car for a traffic stop. And Justice Scalia just wasn't buying it.
I'm going to move us back to your comment on Justice Frankfurter. You were talking about how he had to carefully cobble this decision. When I noted the Red Scare era earlier, Frankfurter, then a professor at Harvard and very active in civil liberties movement, and one of the first non-citizens, if not the first, to ever serve on the Supreme Court. He was derivatively naturalized, was born in Vienna. When he immigrated to the United States with his parents, and then when his father and mother naturalized, he was derivatively naturalized. And in his confirmation hearings, several members of Congress didn't know that he was qualified to sit on the Supreme Court since he was born outside the United States. But he had been a passionate critic of the government for those Red Scare Palmer raids. And another point I wanted to raise was this case, the Abel case, is the end of the 1950s. In 1953, Frankfurter was in dissent in a case about the need for warrants and the need for judicial review of unlimited detention of communists in a case called Carlson v. Landon, decided in 1953. It's a 5-4 decision. The four dissents are Black, Frankfurter, Douglas, and Burton. Frankfurter there, being very true, I think, to his approach and philosophy, is very specific about the scope of power Congress has actually delegated under the Internal Security Act of 1950, and says that the Attorney General, him or herself, is the person who can make a decision about continued detention of someone who's in danger to the United States. It should not be this blanket, all members of the Communist Party can be detained without individualized assessment of their risk and harm to society. In the dissent of Justice Black, he quotes the immigration officials of that time who say that the need that they have to arrest, even without any warrants, they don't always have the proper warrants, members of the Communist Party across the United States, it's akin to, we are not going to release a deadly germ into the country. That to allow these communists, even if all they're doing is political activity or education activity, to speak about their philosophy of communism would be a danger to the nation. And so in this period of the 50s and even into the 60s, many non-citizens lived under severe controls as to their liberty, that they might be released on a bail, but they had to check in once a week or twice a month with the local INS officials. They had to report who they were speaking with, where did they work, how did they earn their living. And this was a really frightening time for these non-citizens who wanted to be engaged in political activity. Something most authors and people don't actually always know, too, is people will just shrug their shoulders and go, well, they should become citizens. Well, Congress had closed that door, saying that if you ever had been a member of the Communist Party, even if the Communist Party had expelled you from membership, you could not naturalize. We still have some vestiges of that today in our modern immigration law. Our government is fairly generous with waivers of inadmissibility if you have been a member of the Communist Party, if you can argue you were a member of a Communist Party under duress, or granting a temporary waiver if you're coming as a foreign student. But these immigration laws are thicker and encrusted and waiting on the books for any time a government official wants to target a population. And your discussion of pretext now is very much the argument challengers made about Mr. Trump's so-called Muslim ban. His initial proclamation, the first days that he's in office in 2017, after his election in 2016, he issues a very poorly worded executive order that had to be rewritten by professionals to withstand constitutional muster. The Ninth Circuit had struck it down, saying that he was using a provision of the immigration law as a pretext for unjustified, expansive use of a national security risk and racial and religious animus. The Supreme Court, taking the case up, I think, on a poorly developed record, expedited treatment, rules, at least the majority, that they will not entertain that argument of pretext. And since there is a waiver possibility, ground of inadmissibility, the government can exercise that discretion fairly. And they do leave open the possibility that later litigation could show that there was racial or religious animus, and there was some litigation successful, not in striking down the president's authority to issue such a wide-ranging religiously based ban, but there was some litigation that did succeed, that some of the people who had been refused admission, it was solely based on their religious identification. I can't help but watch this film and see the echoes and footprints of the case pounding into reality today.
Let me give you not just an echo, but a huge shout for what you just said about pretext. And then I'll reference another case that doesn't involve immigration law. So one of the strongest pieces of evidence that James Donovan presented that the immigration authority was used as a pretext here was an admission to the press, actually, bragging to the press of an INS commissioner named Swing, who said, we knew exactly who Abel was when we picked him up, and we would not have done so but for the request of the FBI. And even this wasn't enough to sway the courts. Now, Abel says that although he was pushed around a little bit, he was never physically abused during his incommunicado disappearance in McAllen, Texas, or subsequently. And that's an important point to make. Not everybody has had that same experience. And a case I'd like to connect this one to is a case from some years ago called Ashcroft versus Abbasi, which involved the Metropolitan Detention Center in Brooklyn, where a number of individuals immediately after 9/11 were rounded up on immigration violations or alleged immigration violations, and were subjected by their own evidence and arguments and testimony to horrific abuse in the Metropolitan Detention Center in Brooklyn. So much so that a lawsuit was brought, made its way to the Supreme Court. Unfortunately, didn't meet with success there. But here's the interesting point. The case was argued in the Supreme Court by Rachel Meeropol, who's a very distinguished human rights lawyer, and her grandparents were Julius and Ethel Rosenberg. Julius and Ethel Rosenberg, of course, were executed for atomic espionage, and there is reason to believe that there are connections between the Rosenbergs and Rudolf Abel. And so here you can really have a very tangible link, both with regard to immigration pretext and with regard to the personalities involved in these cases.
I do want to say that Rachel Meeropol and her colleagues at the Center for Constitutional Rights and Alex Reinhardt, who teaches at Cardozo, did amazing work on behalf of many of these people. And the government did offer a lot of confidential settlements to many of the people who were detained and abused. Most of them were removed from the United States, many of them voluntarily. They had overstayed visas, and they were more than happy to leave the United States, but they won substantial monetary damages, notwithstanding the horrible legal result in the Abesi case. And for the law students listening, Iqbal, which is a case we know about the standard in a civil litigation about what do you have to allege to have a plausible claim for recovery, is one of the parties that was part of this same kind of apprehension and roundup of anyone who spoke Arabic or appeared to be from a Muslim nation who was in our U.S. custody. No one of that group was criminally convicted. These were all civil law violations of overstay or failure to maintain your address record. immigration law is full of traps for the unwary or people who do not know about the way the law can be such a stickler.
If I could just mention one case that isn't involving immigration to show how pretext can work in other circumstances. There was a man whose name will be familiar to many, Jose Padilla, who was seized in 2002 on a material witness warrant in Chicago, sent to New York ostensibly to be a material witness for the grand jury investigation into the 9/11 attacks. But that was just a pretext. John Ashcroft, Attorney General John Ashcroft himself announced via satellite link from Moscow, ironically enough, that Jose Padilla was suspected of plotting a dirty radioactive bomb attack, possibly in Chicago, and that's why he was seized at O'Hare Airport. And then once he's brought to New York on a material witness warrant, on the eve of a hearing before then District Court Judge Michael Mukasey, Padilla is made to disappear into military custody, and several years are spent trying to properly use the habeas statutes to find out what's happening to Jose Padilla, held incommunicado without a lawyer. When the case is finally transferred back into the jurisdiction of the Justice Department, he is then subsequently brought to a criminal case in the 11th Circuit, and there's no mention of a radioactive dirty bomb at all, but there is an example of, I think, quite clear pretextual use of the material witness statute in a post-9/11 counterterrorism case.
A good one and important context. Also, the one other case where you move off a pretext, which, Jeff, you described in your article, post-9/11 cases, on a case of Kid, who was an American citizen, another use of the material witness warrant, and he was detained for long periods subject to abusive conditions. His case goes to the Supreme Court. He had sued Ashcroft as well as line agents. And the suit against Ashcroft is dismissed. The Supreme Court says the suit can't go forward because of Ashcroft's immunity. But Al-Kid on remand is able to get some favorable settlements for some of the FBI agents. And it's interesting because although you can't really argue pretext after Wren, Jeff, as you explained, Al-Kid was able to argue that the FBI or the federal agents misled the judge in obtaining the warrant through reckless submission of false information.
And this is something, if I recall correctly, that Justice Ginsburg points out in one of the concurrences, just how flagrant. It wasn't a one-way first-class ticket out of the country. It was a round-trip coach ticket and all sorts of other extraordinary misstatements.
One of the Supreme Court decisions the film mentions is a case called Yick Wo v. Hopkins from 1886. And it's describing this question, or raised it in discussion of the question of what rights a non-citizen would have against an illegal search.
Can I see the warrant?
For what? Yeah, explain this to me. There was a warrant.
There was a warrant, a civil detention writ for the arrest of an alien, but there was no search warrant or suspicion of criminal activity. So the search and the evidence that is the fruit of that search, that's all tainted and should not be admitted.
What protections does he do, Your Honor? The man is what? He's Rudolf Ivanovich Abel. He is a Soviet citizen. He's not an American.
1886, Yick Wo v. Hopkins. The court held that even aliens, in that case Chinese immigrants, could not be held to answer for a crime without due process of law, including any alien that entered the country illegally.
The Department of Justice has its first allegiance to the United States. I don't see how an alien, if he's here illegally, how he suffered deprivation of rights. Rights as what? An American? Rights as what, Counselor? We're in a battle for civilization. This Russian spy came here to threaten our way of life.
This case involved non-citizens, Chinese Americans. It's a famous equal protection law case that's known to many lawyers and law students. What did you make of the film Citation to Yick Wo?
Well, I was going to give it a B- because I always tell my students, if you're going to name a case in your exam answer, we have anonymous closed book exams often in law school, be sure you have the right case name for the concept you're describing. And the right case name would have been a case called Wong Wing, in which Congress had said if a Chinese national enters the United States in violation of the Chinese exclusion laws, or overstays any permission that they had, they can be sentenced to hard labor. And the Supreme Court rejected that, saying you can't use the civil procedures of enforcing the Chinese exclusion and deportation laws to sentence someone to criminal punishment. They are persons under the Constitution, and therefore entitled to the Fourth Amendment, Sixth Amendment, Eighth Amendment protections, whatever they may be. So Wong Wing should have been the case, perhaps, that Mr. Donovan said. And Jeffrey, I know you reviewed the records. Maybe you want to talk more about that.
Sure. If history matters, then I'd give this an F, but I'll try to rehabilitate the student because I like the film and I like the director. So Donovan in the movie cites the case during an in-chambers meeting with the prosecutor and district court Judge Byers. And he moves to suppress the unlawfully obtained evidence that we've been discussing and cites Yick Wo for the proposition that the Due Process Clause protects even non-citizens unlawfully in the United States. Byers, at least in the movie version of Byers, denies the motion with a snide comment that Abel isn't even an American. But in real life, it was never cited by Donovan in his brief to the Supreme Court. Indeed, neither the Supreme Court nor the Second Circuit nor the District Court ever mentioned the case. The obvious reason why the case wasn't relevant is that Yick Wo concerned an administrative action by the city of San Francisco. That implicated the 14th Amendment, but in Abel's case, it's the Fifth Amendment that's relevant because the FBI was the state actor. Now, beyond that quibbling, there are other reasons. Yick Wo was found guilty of violating a city ordinance against operating an unlicensed wooden laundry. He was jailed for defaulting on a $10 fine. Now, law students learned the case as an equal protection issue. A law that, quote, is fair on its face was applied, quote, with an evil eye and an unequal hand. The court did pause to note in the Yick Wo opinion that, quote, the 14th Amendment to the Constitution is not confined to the protection of citizens. But to do that, it then cited a treaty with China as well as the text of the Constitution and various federal statutes. So as important as this proposition was, it's not the central issue in the case. Ironically, though, the case could have been much more useful for a different proposition, the one that Donovan actually argued. He said the immigration law was used pretextually to accomplish with the INS what the FBI could not do, or probably more likely didn't want to do, arrest Abel and bring him to a public arraignment. Now, Yick Wo can be used to stand for the proposition that motivation matters, pretext matters, that how even a valid law is administered can reveal unlawful purposes and effects of its administration. And that is a violation perhaps not just of equal protection, but also of due process. Now, in 1957, that door was still open. Justice Frankfurter pushed it closed in his Abel decision, but with a little crack left open just in the case, it was slammed shut by Justice Scalia in the Wren case.
Another case I thought about when I watched this film and this idea of selective use of immigration authority. In the late 1980s, the federal government, then called INS, under the division of the Department of Justice, arrested 8 Palestinian people who were attending UCLA. Some were graduate students, some were undergrads. The FBI broke into their dorm rooms of their home, 4 a.m. Again, it's unclear if there were warrants. They were originally charged with being advocates of world communism. As advocates began to represent and defend these Palestinian people who were raising money for the Popular Front for the Liberation of Palestine, the government dropped those charges, alleged technical violations of immigration law, failure to register your address, failure to maintain a full course load, against 6 temporary residents. They were foreign students. The 2 permanent residents, they charged them then with advocating the killing of government officers or the destruction of property. Because by raising money for the Popular Front for Liberation of Palestine, they're saying this is equating to advocating violence or death. This litigation went on for many, many years. The creative lawyers decided to try to stop the deportation machine by going into federal court and seeking an injunction on an argument of First Amendment protection and selective enforcement, saying this is targeting these Palestinian people for unpopular advocacy for liberation of Palestine. And they won. They won at the district court level. They won an injunction. They won many years later. They had to fight for years and years in the Ninth Circuit. And while all that litigation was going on, Congress, largely in reaction to the bombing of the Oklahoma federal building in Oklahoma City, that horrible crime where many, many people died, including children in a daycare center in the federal building, we didn't know that was domestic terrorism. At the time, Congress passed the Illegal Immigration Reform and Immigrant Responsibility Act, sometimes called IRA, and the Anti-Terrorism and Effective Death Penalty Act at very close to that same period. We didn't know that this was domestic terrorism. So it strengthened and broadened the power of the federal government to charge subversive activity. Any aid to terrorism mandates detention, unlike the old case where I was talking about there was a right to a bond to be released. Individualized determination of whether you were a risk to national security. Congress now in Section 236 of the INA now mandates detention. And that's been litigated. And unfortunately, the Supreme Court, a majority, has not cabined it or controlled it. But of these people, this particular case is called Reno versus American Arab Anti-Discrimination Committee of 1999. Justice Scalia shuts the door to the litigation strategy, saying that in 1996, Congress had created a gatekeeping provision of the immigration law, which basically strips jurisdiction of a lower court. And the only time you can challenge constitutional violations or, in theory, selective prosecution or First Amendment violations is after you're finally ordered removed in a judicial proceeding to challenge the immigration determination that went before you, if the grounds of which you're being charged are subject to judicial review. And in other provisions of the Immigration and Nationality Act, there are whole categories of people who are not eligible for any judicial review of their detention, any judicial review of their order of removal. I don't think the American public is very aware of this, and it's become normalized for images on television and in film to show incarceration of foreign nationals, to use the phrase illegal alien or illegal entry as an excuse to characterize them as criminals. When we're using civil administrative law, there's very few categories of law that allow civil detention. Mental health is one, and the Supreme Court has upheld some civil detention for those who are pedophiles. But in those other two examples, mental health and pedophilia, you have a right to appointed counsel. You have a constant right to judicial review of the need for ongoing detention. Whereas in immigration law, we have people that are basically detained for years and years and have no right to free counsel. I just don't think it's very visible to the American public. Every day, more than 50,000 people are in immigration detention, the vast majority of whom are there because they arrived at the border and sought asylum, at an airport and sought asylum, or were apprehended near the border. We're not talking about cases of people engaged in criminal conduct or national security. And you can look at the published data of how often the government is even charging national security. The 3.6 million cases pending in the immigration courts, there's maybe less than 20 that have anything to do with national security allegations.
Yeah, it's important to point out or underscore that in the film, we're talking about someone who was a Soviet spy. But in fact, as we built up this vast system of immigration detention, those type of national security cases are very few, and it's applied against basically regular people who are, in most cases, just coming here to work and improve their lives.
It seems to me that if a broad lesson is to be drawn, it's that cutting corners as certain particular emergencies arise or particularly important cases appear, cutting corners is just never a good idea. We ought to have confidence in and courage to use our existing procedures. Had a warrant been obtained through proper channels to arrest Abel, there wouldn't have been the need for this very close 5-4 judicial opinion. And we wouldn't be having this discussion. Of course, we wouldn't have this movie either. But we see this again and again in the post-9/11 context. The very existence of Guantanamo is an extraordinarily expensive example of cutting corners when using existing procedures would have been a much better solution.
Yeah, I recommend everybody listen to a prior episode of the Mauritanian of this podcast, Law and Film, in which you will hear the story of a man detained wrongly in Guantanamo for, 9 years?
Yeah, he was detained overall for about 15 years, partly in Guantanamo, partly in secret jails, Mohammed Usalaki. But exactly, a good example of cutting corners and not following the rule book, as James Donovan, played by Tom Hanks, puts it in the movie. What makes us Americans, we're all from different places. It's the rule book, the Constitution.
Okay, well, listen, I understand attorney-client privilege. I understand all the legal gamesmanship, and I understand that's how you make a living. But I'm talking to you about something else. The security of your country. And I'm sorry if the way I put it offends you, but we need to know what Abel is telling you. You understand me, Donovan? We need to know. Don't go Boy Scout on me. We don't have a rule book here.
Your agent, Hoffman, Ed.
Yeah.
And German extraction.
Yeah, so?
My name's Donovan. Irish, both sides. Mother and father. I'm Irish. You're German. But what makes us both Americans? Just one thing. One. The rule book. We call it the Constitution, and we agree to the rules, and that's what makes us Americans. It's all that makes us Americans, so don't tell me there's no rule book, and don't nod at me like that, you son of a bitch.
I guess what I was thinking about the film, a second half of the film, where we have Hanks being this diplomat without portfolio and being told to secretly negotiate the spy swap, alleged spy swap with Mr. Powers and Colonel Abel. I found that part of the film less effective. And I think it almost goes into melodrama or almost like bad comedy. And while some of the tension with the building of the wall and the closing of East Berlin society was quite good, overall, I don't know if Spielberg was attempting to portray both societies as wrong and cold-blooded and merciless when it comes to the war, but I felt like he was truncating so much of what was happening in Eastern Germany and how much was controlled by Soviet Union and how much controlled by the Eastern government itself, how much the East government people might have been a victim of the superpower of Russia than the Soviet Union. I'm not sure. I just found that part of the film a little bit more didactic and maybe a little less overall effective. Maybe he didn't want to make Powers less empathetic by making his detention so horrific and the evil portrayal of these cold-blooded diplomats on the Eastern side.
Certainly the second half of the movie is even less significant in Donovan's own lawyer's diary, Strangers on a Bridge. Now, just in temporal terms, Francis Gary Powers was shot down over what was then called Sverdlovsk and what's now called Yekaterinburg. Then in the Soviet Union, when his U-2 spy plane was shot down, that happened on May 1st of 1960. So that's almost 2.5 years after the sentencing of Rudolf Abel in November of 1957. And the exchange for Francis Gary Powers on the Glienicke Bridge doesn't happen until early February of 1962. So this is, I guess, maybe a difficult thing for a filmmaker to portray. There's an inherent drama in the courtroom, at least in an American adversarial process, that probably isn't there quite so much in back and forth diplomatic negotiations, even if you're doing the negotiation in East Berlin. A lot of time is passing. So at this point, Abel is in prison. He's actually physically located in Georgia. And so maybe there's a little more difficulty in portraying all that. From my perspective, and maybe the perspective of this podcast, it was also just a little less interesting to me because we weren't talking about law. We weren't seeing legal issues developed in human lives. Now, there was another person, as you know, if you've seen the film, who was also traded, and that was Frederick Pryor, a Yale graduate student who was arrested and held for about 6 months in East Germany. He went on to become a rather distinguished professor of economics at Swarthmore College. I think he died a few years ago. And he's on record as saying that there were some liberties and licenses taken with his portrayal in the film. He wasn't a tremendous fan, I think it's fair to say. But maybe that's where Spielberg's dramatic interest in presenting the story kind of takes over, and there's just a little less to say.
Do you think the Russian trial of Powers is accurate?
I haven't studied his particular trial, but, you know, it's an entirely different system. If there's tremendous drama in the U.S. adversarial system, that drama is just sucked out of what you could call the continental European inquisitorial system, which is mainly based on a case file, a dela in Russian. And the purpose of the court is to verify the contents of the case file. So that the idea is not that sufficient truth will come out from the adversarial smashing together of opposing sides in a case. The idea is that the search for objective truth is just too important to be left to the parties. And so it's the state's investigator that is going to conduct the investigation. And for a defense attorney to start doing his or her own investigation is almost akin to, interfering with the judicial process. So there's a lot less drama. There's a lot less drama even in the architecture of the Soviet courtroom. If it's not in the case file, it's just not in the world, you could say. And so I can't say his particular trial was fair in the sense that it hewed to the requirements of the Soviet Criminal Procedure Code. I think it's easy to say that it was unfair in that there was quite clearly a predetermined conclusion and a variety of protections that sadly, a lot of Americans take for granted, protections that are both written into the text of our Constitution and are embedded in our concept of separation of powers, are just simply absent from any sort of Soviet procedure.
On the continental point, a good movie, recent movie, Anatomy of a Fall, which I covered in an earlier episode, breaks down a French criminal investigation. I think with a lot of drama built in, I'm not a Russian law expert, but my suspicion, Jeff, is yours, that with the case of Francis Gary Powers, it was a predetermined outcome and there wasn't much drama. In the legal case, the drama, for what it's worth, was, or whatever it was in the negotiation or the political diplomacy that's in the sort of second half of the movie. And some of the kind of interesting dynamics between the Soviet interests and the East German interests, which weren't necessarily totally aligned.
Certainly for those transactional lawyers or future lawyers out there, seeing Donovan's negotiating skills displayed was certainly exciting. But there's a very good reason why there's no Soviet Atticus Finch. And there's a very good reason why there's no Russian film equivalent of 12 Angry Men other than the Russian remake of 12 Angry Men. And that there is this inherent drama to an adversarial court proceeding, especially with a jury, that you just don't get in an inquisitorial system. Not to say the inquisitorial system is necessarily worse or offers less justice, just a different way of doing it, and certainly doesn't lend itself to the same drama.
I feel like maybe we're looking at it from a dramaturge point of view, from the Coen brothers writing the script and Spielberg's film. Maybe this explains in part why he added that probably fictitious scene of the ex parte conversation with Judge Byers and tried to make Byers look prejudiced to balance out the U.S. viewers' reaction to the Soviet trial. Maybe the filmmakers were trying to say both systems had flaws, like trying to be a little bit even-handed there.
Well, thank you for seeing me. I just wanted to give you my 2 cents on the sentencing. And I thought maybe I should pester you at home, as not all of my points are narrowly legal.
Yeah, well, it's that kind of case. I wasn't too scratchy during the trial, but it's exactly what you say. Nothing about this is narrowly legal. There are bigger issues.
Sir, I think it could be considered in the best interests of the United States that Abel remain alive.
Why? I'm not saying I made up my mind, but if he was going to cooperate, work with the government, he would have done it already.
True, but the issue here...
Excuse me. You can't say it's in the best interest of the United States that he spend the rest of his days in a prison cell. How is this the national interest?
Not the incarceration itself, sir. It is possible that in the foreseeable future, an American of equivalent rank might be captured by Soviet Russia. We might want to have someone to trade.
Wow. That sounds like spinning what-ifs. You could do that till the cows come home.
It's my business, what-ifs. I'm in insurance, and there's nothing implausible about this one. It's entirely in the realm of what could happen. It's the kind of probability that people buy insurance for. If we send this guy to his death, we leave ourselves wide open. No policy in our back pocket for the day the storm comes.
Nice speech.
It's true that every system has its flaws, but I wish Spielberg hadn't done that, because I think that U.S. citizens and people in the United States really take for granted, especially our federal judiciary, but our judiciary as a whole. Nothing like that ex parte conversation happened as far as I can understand from the record. And from Byers' reputation, it's hard to imagine, or Donovan's, that it would have happened. And to suggest that that sort of thing would take place and would influence the judge is really casting unfair aspersions on a system and an institution that we disparage at great risk. In most cases, most of the time, I think the vast majority of cases, you have very careful judges doing very careful professional work. And this is, I think, one of the most uncorruptible judiciaries conceived. And to suggest that sort of thing, especially without any evidence, I think, is frankly a little bit dangerous.
There was a scene between Donovan and the CIA officer, the one who later accompanies him to Berlin, where he tries to, it's over at a bar, and he tries to get Donovan to tell him a little bit about what his client Abel is saying. Was that fictitious? That one seemed a little, maybe more in the realm of possibility.
You know, Donovan made very clear to Abel that he took his professional role very seriously, but he also said, I'm a commissioned naval officer in the Naval Reserve, and I take my duty to my country and my patriotism very seriously. Likewise, Abel took his sense of patriotism very seriously. Abel never told Donovan his real name, never acknowledged being a spy, although both of them interacted with each other with that silent assumption just very pregnant in the air. I don't recall reading anything like that in Donovan's diary, but if something like that did happen, based on what I recall from his diary and from what I've learned of the man, I would expect that sort of pushback, leave me alone to do my job.
It's also interesting that Donovan, when he's, talking to the agents, I think it's either the Soviet or the East German agents, he's concerned about what might happen to Abel after he goes back, makes it very clear to them that Abel never turned, that he was a loyal Soviet citizen. There's some degree of respect for that. So what happens later? What is the aftermath for Donovan, for Abel, and for Powers?
You know, that conversation that Donovan has in the film with Secretary Shishkin, you'll recall that Shishkin says to him, well, in essence, of course, you would say that, whether it's true or not true. And so there is this anxiety, I think, that Donovan had about what would happen to Abel. I think it was a very legitimate anxiety. Abel returned to Moscow. He was never put back in the field again. He was left as sort of a more or less desk ornament. He was trotted out on occasion for new graduates in the service, but he was never given any serious responsibilities again, and actually died in November of 1971. I think a much more shrunken and disappointed and frustrated figure, at least from what we can tell from the research that's been done about him. And there are a couple of biographies now, a very good one, for instance, by a scholar named Vin Arthi. So Abel is never put back out into the field. He's kind of an ornament, riding a desk in Moscow. Donovan died in January 1970. He never got that political career that he may very well have hungered after. I believe he lost a Senate race to Jacob Javits. He did, however, continue to work for the U.S. government in unofficial capacities. One of his singular achievements was to obtain the release of over 9,000 men, women, and children after the Bay of Pigs fiasco in Cuba. He became the head of one of the school systems in the New York City area, but as I say, died of a heart attack, I believe, or maybe an illness related to a heart attack in 1970. A relatively young man. I think he was 53 or 54. Francis Gary Powers returns to the United States. He died in a helicopter crash in 1977. He was helping a local television station report on forest fires in California, and there was a failure of the helicopter, and he died in that crash. So they all died relatively young, not really completely accomplishing perhaps all that they wanted to in life. But I think the movie does a good job of showing this particular episode in their lives. And with a few factual flaws and a little bit of Hollywood license, I think it's a good film.
Do you know from anything about Abel, was he actually a painter? Because I thought that addition really humanized him and allowed in the visual media of film a communication of his patience, his professionalism, and then that portrait that he gives to Donovan respect.
He was a painter, and he did have a studio in Brooklyn. I don't know if you want to trust my artistic eye, but I think he was a rather good painter. And you can see a few of his paintings actually in Donovan's work and in the work of some of these other scholars. Ironically enough, it was one mistake involving his art studio that probably led to this entire downfall. And that is that the star witness in the trial, we never actually get to hear the testimony in the case, was an underling of his named Reino Heihanen. And as good a spy as Abel was, that's how bad a spy Heihanen was. And in one, you could say, break in his professionalism, Abel allowed Heihanen to know the location of his art studio. And so when Heihanen later defected to the United States and becomes this star witness for the U.S. government, that's how they began to surveil Abel, because he was able to say, well, he's got this studio on Fulton Street in Brooklyn. And that's when the surveillance begins. But it was that one mistake and related to art. But yes, he really was an artist. And in my opinion, he was a good one.
An art studio in Brooklyn. Certain things are sounding very familiar today. Of course, one of the big things that's changed over time in the movie is there's literally no depiction of women in any kind of professional role, and certainly on the court, but also among the lawyers in the case.
I get the impression the legal secretaries were top-notch. And often in that era, as we even know from Sandra Day O'Connor, when she graduated the top of her class at Stanford, the only job she could obtain was to be a legal secretary. So I thought that world is real, what we're seeing in the film, but it does, when you're watching it through modern eyes, you go, well, where are the women?
I should say, for those who are interested in the facts on the ground, so to speak, I participated some years ago, and I think it's available on C-SPAN, in a Brooklyn Historical Society event in which shortly after the film came out, James Donovan's son, Anthony Palermo, the last surviving prosecutor in the case, Vin Arthi, a biographer of Abel, and myself appeared to discuss some of the factual details that we've discussed, among other things. It's certainly true that there's that accurate depiction of the absence of women in this film, in those leadership roles. Also, I think it's fair to say that the film also is not a very multicultural, a multiracial scene displayed. For all of New York's vitality and diversity, we get a very monochromatic view of 1957 Brooklyn and Manhattan. And, that's also so noticeable.
Well, Jeff, Lenni, it's been so great having you both on the podcast for this deep dive into Bridge of Spies and the array of legal issues it raises. So I want to thank you both again.
Thank you.
Thank you very much. And thank you, Steven Spielberg and the cast of the film, because it is definitely worth watching.